for the House Corrections and Juvenile Justice Committee to order. We will be hearing on Senate Bill 459, which concerns the membership of the Prisoner Review Board. But before we go to that, I wanted to just mention what probably most everybody in the room knows, that we lost a dear colleague this morning, the Vice Chair, John Ressman. And so we're all mourning that, and I wanted to give anybody on the committee an opportunity, but don't feel obligated. We did, on the House floor, gave remarks about him, and so but if anybody on the committee wishes to say anything, we would welcome that. Yes, Representative Smith. Mm-hmm.
For those of you that didn't hear me, Mr. Ressman was my cellmate when I came back up 6 years ago. And like I say, we talked about him going to Australia. Our office aide gave her opinion of both of us. And it seemed like every time I called him during the summer, he'd be down in Alabama on the beach. And he said, "You always call me when I'm on the beach." I said, "Well, I just wanted to say hi." And anyway, he brought me back a T-shirt. And that T-shirt has become real special. John was a special man. And like I say, I enjoyed keeping in contact with him. And I'll miss him very much. So thank you, Chair.
Right, so he served on this committee, I believe, from the time he entered the House back in 2017, and was very helpful to me as the chair of these last two sessions. So with that, we will move on to the agenda, SB 459. And I will ask the first proponent, Jordan Cheshire, president of the Heaven Child Advocacy Group, to approach the lectern if he's in. Oh, actually, I'm sorry. Why don't we have the reviser give us a review of the bill? I apologize. Thank you.
Thank you, Mr. Chairman. Jason Thompson, Revisor's Office. Just to give you a little background on the bill as usual. Senate Bill 459 comes to you. You should have the version as amended by Senate Committee of the Whole. That is the most recent version. It was requested for introduction in Senate Judiciary by Steve Kearney on behalf of the Kansas State Troopers Association, and it passed the Senate eventually 33-7, and it found its way to you today. So the bill changes the membership of the Prisoner Review Board, and it also deals with parole hearings and some public comment session requirements. Section 1 is the amendment to KSA 223717. That's the statute concerning parole eligibility, post-release supervision terms, and also notice requirements for parole hearings. Subsection H is amended in this section, and that is the one which deals with notice of hearings. The amendments in the bill would require the board, the Prisoner Review Board, to give notice of each parole hearing to the Attorney General. That is not currently found in law. And the amended subsection also provides that the public comment session of a parole hearing shall be held in person unless the victim or victim's family requests otherwise. So those would both be additional additions to the current law. Furthermore, if the inmate was convicted of either an off-grid felony, which is post-1993, or a Class A felony, which is pre-1993, current law requires the board to postpone a decision for at least 30 days after that victim notification. The bill would require in those same cases that the board postpone the public comment session until 30 days after notification has been provided. and add a provision that the board shall not make a decision on parole of those inmates until after the public comment session for that inmate is held. So there's some lengthening of the timelines there based on the notification in those what will usually be off-grid felonies, but could also be Class A felonies from the earlier law. Finally, current law requires the board to consider the capacity of state correctional institutions when evaluating whether to grant parole, and the bill removes that factor from the consideration. So you'll see a list of factors in the bill, and that one is removed from the current law. Section 2 then deals with the other part of the bill that I mentioned at the beginning, the membership of the Prisoner Review Board. Current law provides for 3 members of the board. All 3 are appointed by the Secretary of Corrections. And it's been that way since an executive reorganization order was adopted in 2011. So that was the last time that this was changed. The amended bill would make the board 5 members, and all 5 members would be subject to Senate confirmation. 1 would be appointed by the governor with at least 5 years of law enforcement experience, another appointed by the governor with experience in serving victims of crime, and another appointed by the governor with no specific experience requirements, just general background that's required in another part of the bill. So 3 members appointed by the governor. And then a 4th member appointed by the Attorney General with at least 5 years of experience as a prosecutor. And the 5th member would be appointed by the Attorney General. Again, no specific experience requirements for that person. So 3 by the governor, 2 by the Attorney General. That would be the new 5. The amended bill also provides that not more than 2 of the 5 members shall be from the same congressional district. And I meant to point this out in the brief, but I'll at least point it out to you now. That was the subject of the Senate floor amendment. So the Senate floor amendment changed the provision to reflect that no more than 2 of the 5 from the same congressional district. What was sent to the floor was that no more than 3 of the 5 shall be members of the same political party. So many of you have been around for a while. You'll recall that on various boards there are some restrictions on political party membership or congressional district residency. And the shift on the floor amendment was from the political party focus to the residency, the congressional district requirement. So I thought I should point that out. That was a change that happened on the floor. And then the last thing I'll say is that the terms are staggered for the new members, and the current members that are serving would all end their terms on July 1st of 2026, and you would get a new board. So there's a little bit of mechanics in there with the timing that I think you're going to hear about from the conferees. But that is what the bill says anyway. Current members would expire on July 1st of this year, and new members would need to be appointed and confirmed by the Senate after that. I'll be happy to answer questions if I could.
Yes, question from Representative. Are you over there? Yeah. Carmichael. I'm a little bit not focused today.
Thank you, Mr. Chair. It's been a difficult morning for us, and I'm sure it's also a difficult day for the survivors of Trooper O'Brien. My question for you, though, Mr. Revisor, is the move from no more than 3 members of the same political party. Was the no more than 2 from one congressional district a substitute, if you will, for that requirement of no more than 3 from the same political party?
Mr. Chairman, yes, Representative. If you look in the current version of the bill amended by Senate Committee of the Whole, it's on page 14, and it's in lines 23 through 25. So as it went to the floor, it said not more than 3 of the 5 members shall be members of the same political party. And as it left the floor, it now says not more than 2 of the 5 members shall be from the same congressional district. So it is a substitution. They are not both in the bill anymore.
I see that now. Thank you for your guidance. Thank you, Mr. Chair.
Any further questions from the committee about the bill? Thank you, Jason. All right, now we'll go on to the conferees. The proponents, the first proponent to speak is Jordan Cheshire, President of the Heaven Child Advocacy Group. Welcome to committee.
Good afternoon, Chairman Lewis. Members of the committee, thank you for the opportunity to submit testimony in support of Senate Bill 459. Project Heaven is a Kansas-based child advocacy organization that engages directly in public safety issues, including monthly parole review participation. Since beginning this work, We have reviewed and challenged hundreds of parole considerations across Kansas. Through this experience, we have identified several concerning trends that Senate Bill 459 directly addresses. We consistently observe parole releases where individuals return to custody shortly afterwards for violations despite receiving no new criminal charges. Many of these cases involve lengthy disciplinary histories within the correctional institutions and failure to complete available education, treatment, or rehabilitation programming prior to release. When individuals are released prematurely and then return to prison, it creates strain on local law enforcement, supervision resources, and taxpayers while placing communities and families at unnecessary risk. Project Heaven believes strongly in accountability balanced with opportunities for rehabilitation. We support second chances when they are earned and when public safety remains the priority. However, decisions that impact our community safety should never hinge on a system where only 2 members of a 3-person board must agree to grant parole. The current structure increases the risk of inconsistent decision-making and places too much authority in too few hands. Senate Bill 459 improves this process by expanding the Prison Review Board to 5 members, diversifying professional backgrounds, strengthening qualifications for service. These changes bring broader expertise and a more balanced evaluation of each case. The bill also improves transparency and fairness by ensuring victims receive proper notice before parole decisions are made, a safeguard that reinforces trust in the system. Additionally, removing prison capacity as a factor for release is a critical reform. Decisions about parole should be based on readiness, risk assessment, and demonstrated rehabilitation, not on the operational needs of correctional facilities. Public safety should never be compromised due to space constraints. From the perspective of advocates who interact within this system month after month, Senate Bill 459 represents a thoughtful and necessary modernization of Kansas parole structure. It strengthens oversight, promotes balanced decision-making, and promotes the safety of children, victims, communities across our state. We respectfully ask the committee to support Senate Bill 459. Thank you for your time and your continued commitment to the safety of Kansas families. I'll stand for questions when appropriate.
Thank you. We'll go ahead and take questions for this conferee now, if there are any. Thank you for coming. I have a real quick question. Your group, your Heaven Child Advocacy, indicates in your testimony that you watch the parole board and review board and are engaged in that. What other, if any, other activities with respect to children do you engage in as a group?
So as a group, we advocate for victims of child abuse. A lot of it lately has been legislation. We're still in our infancy as an organization and still building a coalition within our community. But we talk with families, we figure out their needs that they want, and we try to educate the public as best as possible.
If I might, so for instance, when you do make appearances before the review board, is it mostly or exclusively on behalf of victims of child sex abuse of some sort or child abuse?
Yes, our organization focuses on predators and child abuse. We have put in opposition testimony for murder per se that involves children. We only have publicly available tools to do this with, so we're not able to totally sort out everybody, and a lot of child cases tend to be sealed within the court system. But yes, we do specifically seek out ones that harm children.
Yes, Representative Smith.
Thanks, Mr. Chair. Just wondering, how many parole hearings would you hear in a month or in a year? Do you have any idea on that?
Yeah, so we will go through on the website. They'll post who's going to be paroled, not immediately that month, but within the 2-month time frame that they allow. We'll go through, we'll take them all down, and then we'll sort through them. We'll go through their case files. We'll get information from the courts and go through there. I would say, we've been part of dozens now. I even listen in on Zoom and observe on Zoom when they do I guess that's their in-person.
Yeah, I like that. But, you know, getting 5 guys or 5 women together, it seems like it'd be difficult for, if you keep them all day long, or, you know, they have other duties, so just wondering about that, so, thank you.
Right, thank you. Appreciate your coming and talking to us.
Thank you.
The next conferee is Steve Kearney, Executive Vice President of the Kansas State Troopers Association. Welcome to the committee.
Thank you, Chairman.
Good to see you.
Members of the committee, I'm Steve Kearney. I'm here appearing in my capacity representing the Kansas State Troopers Association. As many of you, I'm sure, recall, just this last spring, what brought this to our attention was what I would call, for us anyway, the surprise and shocking parole of Jimmy Nelms, who had executed Trooper Conroy O'Brien back in the 70s in the ditch. And, you know, as a murderer of law enforcement in the performance of their duties, we were very surprised to see that this individual had been paroled. It created, as you all probably recall, quite a little firestorm in the press and otherwise, and ultimately the decision was reversed, but not without a lot of whole lot of discussion and pressure and otherwise. And what we discovered, and maybe kind of shame on us, Chairman and members, that we hadn't looked more closely at the parole structure since it was changed in 2011. This is the first time this really popped up in front of us. But what we discovered, and for those of you that are like maybe Representative Carmichael's old enough like I am to remember how the parole board used to be, you know, 5 folks, and it used to be a little broader, and it was not housed necessarily under the Department of Corrections. Well, in 2011, by executive order, it was moved over under the Department of Corrections, pared down to 3 folks. Those 3 folks, as near as we've been able to discern, are career correctional employees, which, and God bless them for doing that and for their public service there. But we feel like when those folks are serving at the pleasure of the Secretary of Corrections, that the Secretary of Corrections in that department has overarching concerns constantly and a pressure on them about prison bed space, et cetera, that at least for these types of felons, the off-grid Class A felons, murderers, people that I would consider to be evil, that should die in prison, those folks need to have a little different kind of consideration. And I think through COVID, like many of us, right, there was more electronic presentations, more Zoom, more et cetera. So I suspect that, or at least anecdotally, I understand that some of those hearings and comment sessions became a little more distant. Well, you guys and gals know that here we are face to face. It has a different feel, right? And we're talking about folks that have taken someone else's life and providing the victim the opportunity to speak to that directly. This isn't, at least for these categories of felons, this isn't a convenience matter. This should be a matter of public safety, of victim consideration. And as we looked at it, we thought, okay, they can actually go ahead and parole them even if the victim didn't get notified. They don't have to wait. It's not cause or standing to wait for the hearing, so you can actually hear what folks that have been the victims of these crimes have to say, or the families of the victims of these crimes. So we went through it and looked at various other states. Bottom line is it kind of returns us towards, as Mr. Thompson said and Jordan said, returns us to a 5-member parole board. And establishes some specific qualifications for folks, not just career correctional folks, but someone from law enforcement, someone from prosecution, et cetera. And admittedly, the bill came out of the Senate off the floor a little bit differently than we had crafted it, but it did still maintain all those factors that we were most concerned with, which is establishing a separate board with folks that have qualifications, with a higher number of folks, making sure that the notice provisions for the victims were addressed and straightened up. And in particular, in the list of considerations for someone as they're coming up for parole, prison bed space availability is stricken out of this bill, at least as far as we're going to, at least for these more serious felons, to weigh public safety against the economics of building a new prison. And I get it. I've been around here for a while, as you guys know, and I know the uneasy tension that exists between the budget and how do we fund law enforcement, how do we fund corrections, how do we build prisons. But these are not folks where that consideration, I don't believe, and neither does the Troopers Association, should not come into play. So we've struck that from this bill. Beyond that, Mr. Chairman, I mean, I'd be happy to answer questions, but I think you guys have the basics of it, and who appoints who and how that happens and the length of the terms, et cetera, was something that we really didn't try particularly to weigh in. And we feel like as policymakers, we want to bring this problem to your attention, and then you all decide the best way to sort that out.
Thank you, Mr. Kearney. Any questions for the conferees? We'll start with Representative Barrett, and then we'll go to Representative Carmichael.
Thank you, Mr. Chair, and thank you for your testimony. Yes, on the changes made on the Senate side, does the association have any stance on that, or just remain neutral?
No, we're remaining neutral. I mean, once again, the basic elements of what we were trying to accomplish: 5 more qualified people. You know, confirmation by the Senate's probably a great idea. Years and years ago, as Representative Carmichael probably remembers, sometimes the parole board turned into more of a kind of a plum appointment sort of a thing, and maybe some question as to whether the folks were highly qualified or experienced that served on it, and we try to solve that with this. So,
thank you, Mr. Chair.
Thank you, Mr. Chair. Mr. Kearney, I appreciate the acknowledgement of our old age.
We got to get something out of it, John.
Starting to catch up with us, maybe. My recollection, although I didn't actually come to legislature until 2013, but my recollection was the change from the prior composition, and I do think there were some people who were appointed as political plums at that time. By the way, Representative Sawyer was on the parole board at the time. You might want to ask him about how tasty the plums were.
Right, yeah, exactly. Yeah, how many miles he had on his car, I know.
Right, yeah. And I just say that for the committee's reference, because if you want to know how it used to work, you have an expert here in the building who I'm sure could tell you. But what happened, I think it was in 2011, as I recall, was at the instigation of the Brownback administration, in response, in part at least, to concerns that the parole board wasn't professionals, and perhaps some concern that they were too generous in letting people out. Now, I don't know if it went that far. I see you frown a little bit.
Yeah, I'm not sure either. That's me trying to think.
Yeah, and don't hold that as gospel, what I just said.
Right.
But that was a reform proposal implemented by the Brownback administration, and now we sit here 14 or 15 years later looking at a different reform proposal. I'm just add that for historical benefit.
Yes, I think that's absolutely correct. And all I can say is that sort of my recollection around those years, well, a lot of this was consolidation of efforts and some savings also, because I remember the JJA was folded in about that same time, if not that same time, under the Department of Corrections, et cetera. So there were several changes, but the transparency and the accountability of the way we're doing it today has caused a great deal of concern.
Mr. Chair, with your leave, though, I do want to ask something else that's almost a statement, but I'll make it in the form of the question. I knew Conway O'Brien. Okay. He played basketball in the mornings at my high school with other current and retired law enforcement officers. They came in at 5 or 6 in the morning. And I remember the day he died. And I remember the day Bud Pridno died as well. Officer Pridno lost his life as a member of the Highway Patrol, as I recollect, on the Turnpike as well, under circumstances that to some of us were remarkably similar and almost haunting what happened to both of those troopers. And I see Sheriff Easter sitting back there. It was a bad time for law enforcement there in the mid-'70s. We lost Vance Johnson as well, of the Sedgwick County Sheriff's Office. My recollection is that Mr. Johnson's murderer died in the state penitentiary. I read it in the Retired Copper, which is a newsletter for generally Sedgwick County law enforcement officers and the like, and I shed not one tear. And I remember the guy's name, and I remember the circumstances. So I hope people in this room understand that at least this representative, oh, and I should also mention Alvin Wolf over in Towanda, who was killed by, I know that guy's name too, but I ain't gonna say it, a guy who rammed his patrol car and killed him in the front yard. So, yes, we absolutely need to be doing things, but I guess to roll back to where I was really coming from, I think at the time these crimes were committed, had they been committed now, these people who murder law enforcement officers, they stand in line for capital punishment or a lifetime sentence. I think that's generally what the law provides now.
Yes, that's exactly correct, Representatives. This particular murder and execution took place in that narrow window of time where the United States Supreme Court had struck down the death penalty across the nation. And Kansas had not yet reinstated its death penalty. Had it occurred, if it occurred today, no question he'd be subject to the death penalty.
And if not the death penalty, there's provisions for life imprisonment as well, and you don't worry about a parole board.
Parole wouldn't be a discussion, yeah. Yes, sir, that's correct.
So I guess, Mr. Chair, to some extent, that's progress, but I know that doesn't come as solace to those who lost loved ones 40 some odd years ago.
Exactly.
Thank you, Representative Carmichael, for providing us with that historical perspective. Just reading about it, it was an awful and senseless murder, and that's why we're here today. Yes, Representative Smith.
Thanks, Mr. Chairman. It seems like I hear on the news or read the paper that somebody got lifetime sentence and they still get paroled, or lifetime without parole, can they still get paroled? It just seemed like I've heard that before. Is there any truth to what I'm saying?
So I suspect there is, Representatives. Our sentencing guidelines are, for those who don't live with them every day, fairly complicated, but I think when someone gets a life sentence without a parole, then that's what that should mean. And I think in other instances, they may receive a lengthy sentence, but they still have conditional release dates, et cetera, that are available to them.
You know, I just heard the other day somebody got double life sentence and they still got out, and I just don't understand that. So thank you.
Yes, sir, it's a quandary, if I might, Mr. Chairman. This particular individual, Nelms, was actually on parole from Oklahoma, as I think were a couple of his cohorts when they murdered Trooper Conroy, who I didn't mention earlier, but had an expectant wife at home and a daughter that never ever got to know him or see him. Just the other day, and Chairman Lewis, if I might, I just mentioned it briefly, but I believe this to be the case, that just over into Missouri, we had 2 deputies killed, and they were killed by an offender that was on parole from here in Kansas, And I think he was paroled in 2023, having shot at some Johnson County deputies back in 2015, something like that. Didn't hit them, but went to prison for aggravated battery on a LEO, et cetera, and then out on parole, and it's not like a year and a half after he's killed, taken the lives of 2 law enforcement officers just across the border in Missouri.
Any further questions? Yes, Representative James.
Thank you, Mr. Chairman. You had spoken, while you were talking about the bill, you had spoken that something was stripped out of the bill. And I was wondering, is it, in your mind, is this the best bill we got? Did you get everything you wanted?
So, well, gee whiz, it's tough, careful when you ask that kind of question, but it does contain all of the original elements that we were after, without a doubt, in terms of the number of folks, that they're qualified, that it's a wider experiential group of people that have been out there and done it, seen it, not just folks that have grown up necessarily in the corrections environment. Yeah, I think so. I think so. It's what really got moved around was how do folks, who appoints who, and for how long, and how do those terms work? And I appreciate your question very much, Representative James. And there is one thing that I would point out to you that has been raised, and I think Ed Klump and I talked about it just the other day as well, and I want to steal his thunder because I think he spotted this, but you'll notice in the bill, and I think Jason mentioned that the term of the current Prisoner Review Board, the terms of those members would end July 1, 2026, and that the new members, if you will, would begin their service then. I'm just thinking about the practicality of Senate confirmation, finding these people, discerning all of that. I guess what I'm trying to say, not in a not very articulate fashion, is we can't have a time when no one is serving in that capacity. If those folks are done on July 1, 2026, and there aren't 5 folks ready to rock and roll, there's a lot that group considers and deals with, from parole to clemency to other things. So that's worth you all taking a look at for sure.
Thank you, and thank you, Mr. Chair.
All right, seeing no further questions. Thank you, Mr. Kearney. Appreciate it.
Thank you, Chairman.
The next conferee is Sheriff Easter, representing the Kansas Sheriff's Association. He's their legislative chair.
Good afternoon, Chair and Committee. My name's Jeff Easter with the Sedgwick County Sheriff's Office, but I represent all 3 associations today, the Kansas Association of Chiefs of Police, Kansas Sheriff's Association, and Kansas Peace Officers, in support of this Senate Bill 459. A couple of things, and I won't belabor this too much because I think the previous conferees have explained it very well, but one of the changes will be a public comment session shall be held in person unless the victim or victim's family requests otherwise. Secondly, the public comment session for such inmate to a time at least 30 days after notification is given is provided in this section. The board shall not make a decision on parole of the inmate until after the public comment session for such inmate is held. I think those are 2 key factors to this particular bill. The last piece, which has been thoroughly discussed, it has changed from when it was on the Senate side, but again, it still allows for the governor and the attorney general to appoint 5 members to this board that have specialties. As a prosecutor, 5 years experience, as a law enforcement officer, 5 years experience, and then also as a victim advocate. So we think that all of those are very a good amendment to this particular bill. The last thing I'll tell you is that it's not just law enforcement officers that have been killed in the line of duty, and parole or being able to say you've been convicted and you do life without parole doesn't actually mean that still. But there's a lot of other victims out there that have suffered from some of these same type of decisions that were made in the parole board hearing, and I'll highlight one of them. In February of 2025, Jeremy Miles committed a first-degree murder and criminal possession of a weapon by a convicted felon. He had prior convictions for attempted aggravated robbery in 2005 and was given probation. 2 years later, he was convicted of attempted aggravated robbery and criminal possession of a firearm and sentenced to prison. While in prison from August of '07 to August of '21, he had 56 disciplinary actions on 41 different dates. He was released from prison in state post-release in August of '21. Less than a month after release, in September of '21, a warrant was issued for his arrest for violating his parole. In September of '15, a second warrant was issued for violating his parole. He was returned to prison on September of '21. Mr. Miles was released from prison again, and then on November of '22, DOC issued a warrant. He was placed back into prison and then released again. In January of '23 and on February of '23, DOC issued warrants again for parole violations. In February of '23, he was returned to prison. During this day, between March of '23 to May of '23, he received 4 disciplinary reports, and 2 of those were for battery cases. In August of 2023, he was released from prison again. Within 7 days of this release, he committed murder. We question the board as to why they felt he was reformed enough to be granted parole with this extensive history of being released and then committing numerous violations and being sent back to prison on several occasions. While in prison, he had 56 disciplinary actions plus 4 more violations, his last stint in prison, 2 of which were for battery. Prior to his release, just prior to committing murder. Our belief is based on his history and was not reformed and should not have been granted parole. And with that, I'll stand for any questions.
Representative Seibert.
Thank you, Mr. Chair. Thank you, Sheriff. Did you say that inmate's name was Miles?
Yes.
Was it Maurice?
No, Jeremy Miles.
Okay, because there's that name sounds very similar to the person that's broken in our house and stole several things several times. And I think the sheriff in Reno County, and I think you know who he is too, and he's been released on bond numerous times and committed other crimes, and they sent us a letter that he was back out again. My wife was home alone when he broke in our house, and so she's there now with him, possible flight. Thank you. Anything I can do to help you, let me know.
Thank you, sir.
Representative Smith.
Thanks, Mr. Chair. You mentioned he was released several times. Was he released by the parole board every one of those times?
Yes, he was.
Wow. Thank you.
Seeing no further questions, thank you.
Thank you.
Sheriff. All right, we're going to move on now, unless there's someone else in the audience that wants to speak as a proponent. We're going to move on to the opponent testimony. Emily Brandt, criminal defense attorney.
Good afternoon, Chairman Lewis and members of the committee. My name is Emily Brandt. I'm a criminal defense attorney. You have my written testimony, so I won't belabor those points, but I do want to highlight a couple of things. First, I appreciate Mr. Kearney pointing out the possible timeline issues with the bill as drafted. I think he's absolutely correct that it seems a stretch that the new members could be appointed and confirmed by July 1 of 2026. And again, there can't be a lapse in what this board does, because I think, and again, I don't work for DOC, so these maybe are questions for DOC or things for the committee to look into, but it seems that what the proponents want to do, and I take no issue with it, is establish a true parole board. This bill does not do that. We have a prisoner review board that does things like parole and post-release and contemplates things like violations of post-release. So they're doing a lot of administrative functions, which is why they're currently employees of the Department of Corrections. They are full-time employees working day in and day out to do all kinds of things that are not parole decisions. I think I can agree with the proponents that maybe people who would be subject to terms of parole, so people who have committed off-grade crimes such as first-degree murder, felony murder, child sex offenses, that maybe reviewing whether or not they're eligible for parole should have different consideration than people who are going to leave KDOC on post-release. I can agree that maybe there should be 2 entities This bill does not create two entities. It just changes the makeup of the prisoner review board that does things beyond parole. I think sometimes, and again, I believe DOC is here and they can correct me if I'm wrong, but sometimes we use the terms post-release and parole interchangeably in the state of Kansas because most people are going to leave KDOC on post-release because of the way we've changed the sentencing grids. Right, so post-release is mandatory. It's not something that theoretically could happen. Everybody that leaves DOC has a term of post-release attached to their term of imprisonment, and parole is discretionary. So, right, again, like I think we talked about people who maybe receive what some people call life sentences. Under the grid, they're really like 25 to life. So after serving 25 years, they are parole eligible, and that would be a discretionary decision made by the Prisoner Review Board. Every other offender in DOC is going to leave DOC on post-release. And so I'm not actually sure that the gentleman that was spoken of that was released from KDOC multiple times was actually released on parole. He was released on post-release, violated the terms of his post-release, went back in. But like, you have to leave DOC when it's post-release. It is mandatory that you exit DOC with the term of post-release. You can violate that term of post-release and serve out that term of post-release in DOC, but you have an out date. Like, you're going to leave DOC and finish your time on paper, whereas that decision is discretionary when it comes to parole. So I just want to highlight those two things. That one, I think that if the bill is going to stay as is, that timeline needs to be adjusted. But secondly, I think it is maybe wise to go back to the drawing board on this and determine whether or not it is time to separate the Prisoner Review Board into two separate entities. One entity that is staffed by the Department of Corrections that does the day in, day out logistics of post-release, violations of post-release, et cetera, and a true parole board. And I would stand for any questions at the appropriate time, but I think those are the two main points that I wanted to make, that I don't actually know that this achieves what the proponents are hoping to achieve, and two, I think that the timeline needs to be adjusted.
Thank you, Ms. Brand. I have a question on your point about perhaps establishing sort of an administrative group of employees and then the parole board. Do you know if that's done in other states?
Chairman, thank you for your question. I do not know. I don't know what other states are doing, but again, it just sounds like the way we're speaking about it is a parole board, but Kansas doesn't have a parole board. We have a prisoner review board that does all the administrative post-release stuff and the parole decisions. So I'm not sure what other states do, but I think that would be worth looking into. And I think would probably better address what the proponents are hoping to address. Again, if you look at the fiscal note on this bill, it's suggested in like the next fiscal year, it's going to cost like another $300,000 from the state general funds to add 2 members to this board. But I don't know why that would be if the point is that they no longer work for the Department of Corrections. So who do they answer to? Are they FTEs of the state of Kansas? Again, the way that it works now is that they are, because it's a full-time job. I think if you were going to have people that serve on this as volunteers or something else, I don't know why they would be full-time members or full-time employees of the state of Kansas or employees of the Department of Corrections, since it seems to be antithetical to what the proponents want, that these people would be housed under the Department of Corrections.
Any further questions? Representative Carmichael.
Thank you. As always, I appreciate receiving at least 2 perspectives, if not more, so thank you for being here. I don't know if you've had a chance to look at Secretary Zamuta's neutral testimony, but he reports to us that the Prisoner Review Board in fiscal 2025 rendered 5,482 decisions. And it's, what is it, a 5-member board? And it's a 3-member board. I don't know how many judges you appear in front of that decide 5,500 cases a year. But that kind of suggests to me that maybe we ought to think about dividing the administrative, if you will, responsibilities of DOC versus a parole board, so that maybe people given more time and resources could make better decisions. Do you have any comment on that?
Mr. Chair and Representative Carmichael, thank you for your question. I've not had an opportunity to review that neutral testimony, but I am pleased that that neutral testimony is before this committee. But I would say, again, I think that it's 5,000 because, again, every single offender in DOC is going to leave DOC on a post-release term. They have to review every single one of those post-release plans. And if any of those offenders violate post-release, they have to review those violations and determine whether or not that offender should come back into DOC custody for a period of time. And so, again, if the proponents truly want a parole board dedicated to making decisions in the best interest of the offender, the victims, et cetera, I think you would need to break this into two boards, one doing the parole discretionary determination and one doing the everyday KDOC determinations that are mandatory and required to be done by somebody. And I don't know how a 5-member board of volunteers could do that, unless they're employees of DOC, which this bill and the fiscal note sort of suggest they still would be, so.
Thank you. Any further, Representative Smith?
Thanks, Mr. Chair. I apologize for talking so much. Post-release, I don't understand how somebody could have 50 violations against them while they're in prison and then get a post-release. I thought you got released on good behavior, not when you have all these violations. So thank you, if you'll answer that.
Mr. Chair, and thank you so much for your question. So it's a couple of things, right? When a criminal defendant gets sentenced to a term of incarceration, right? Let's say that their prison sentence is 12 months. They are also going to receive a post-release sentence, and based on a 12-month term of incarceration, probably a 12-month term of post-release. So they are going to serve 12 months in the Department of Corrections. Upon finishing that 12 months, they will then serve 12 months of post-release out in the community. If they violate that term of post-release, they could return to DOC to finish out that 12-month term of post-release. They could be, that 12-month term of incarceration, that 12 months could be less than 12 months if somebody has good behavior. So again, at a 12-month term of incarceration, you could earn up to 20% good time behavior. So if you have no violations while serving your term of imprisonment, you could leave KDOC onto post-release early, but you are always going to leave KDOC. It will either be after serving the entirety of your sentence, and if you've got 57, disciplinary violations, you've probably earned 0% good time. So you're serving day for day, those 12 months, and then you will leave on post-release. If you have 0 violations, you might serve the 12 months minus 20% of good time, and then serve your term of post-release. So post-release is part of a criminal defendant's sentence. It is always established at the time of sentencing, and any offender going into KDOC on a on-grid crime, which is nearly everybody going into KDOC, they're gonna leave on post-release. It is mandatory to leave on post-release. They may get out earlier if they have good behavior.
Representative Butler.
Thank you, Mr. Chair. I'm not sure if this is for you or for the previous conferee, but I've heard both of you say that there is a concern about all members being able to be appointed on 1 July when the other ones expire. Would it maybe make some sense to stagger the way that we do things? A lot of commissions have where the 2 will come on this year and 3 will come on 2 years later. So you stagger them versus all 4 of them coming on at once, or all 5 of them coming on once.
Mr. Chair, Representative Butler, thank you for the question. So they have made it so that the new board members come on at staggered terms, so we wouldn't see this moving forward. I think, which again, I don't totally understand the bill, so again, maybe these are questions for the proponent or DOC, but I think, as written, the proponents no longer want members of the board to be employees of KDOC. They would no longer be full-time employees of the state of Kansas. They wouldn't be like quote-unquote professional corrections officers. They would be people with other experience, such as a prosecutor, or law enforcement, victims' right advocates. And so if that is the case, all 3 of the DOC members would need to leave so that the new board with non-DOC employees and other credentials could all start. So I don't know that it would meet the proponent's needs to have some DOC folks still on the board and some non-DOC folks on the board. Again, I think that probably needs clarification. But I assume that's why they didn't stagger them.
All right, I don't see any other questions, so thank you very much. I just, Mr. Kearney, if you could address sort of the general question of how do you understand, well, hold on. Actually, let's ask the revisor first, and then I'll ask you to follow up. That makes more sense.
Thank you, Chairman.
Yeah, could you try and walk us through how you believe the bill would treat the parole board in terms of it's not a KDOC employee, or are they going to be, is there going to be some sort of staff? Would that be determined by them? How does it get financed? That kind of thing.
So, Mr. Chairman, the main thing is that the board itself, currently they are under the Secretary of Corrections, and that's removed in Section 2. So that's the main change. I was attempting to look at the fiscal note while we were talking to see how they arrived at that conclusion. So, Mr. Chairman, the part that's not struck from the current bill is that the board does exist within the Department of Corrections. It's just that the members will not be appointed by the Secretary, and they will not be existing employees of the department. Those are two pieces that are struck at the top of page 14, for example. So being housed within that department, that means they would have to provide staff and resources, and that's probably where the fiscal note comes from. As far as, and I actually thought about this when we were doing the bill brief, the old, I was here in 2011, and I was looking back at the ERO and then the legislature's implementation of that in 2012. They repealed two statutes, one that established the old board and had who appointed them, and the other was their compensation and salary. And so I don't know what the compensation and salary would be for these new folks. I was trying to dig into that, but I haven't had a chance to find anything beyond they would be within the Department of Corrections. So, but under the old parole board, they were paid the salary of, the chairperson was paid the salary of a chief judge of the district court, and the other members were paid some that was specifically below that. So it always moved, and the other folks would move with them. But I don't know that that exists in current law or in this bill. So it's kind of an interesting question about how they would be compensated. And I don't know that I have an answer from the bill itself.
Yeah, Mr. Kearney, you can talk to either what you believe the bill does or what you think the bill should do.
We did, as is typical, revisor is correct. However, what we anticipated was, well, we've got a three-member, right now we have a three-member board, if you will, right? And they're housed and staffed under the Department of Corrections. So that piece in and of itself wasn't really where our concern lied necessarily. It was the makeup of the board and the fact that the selection of the members of the board was, and they served at the pleasure of the Secretary of Corrections, and that uneasy tension, if you will, or public policy question that brought up. Part of our original thinking was we have a board, we have a staff, we have three folks. What we would need to do basically is add two more folks and decide how to compensate them. And we were trying, and also understanding or having appreciation for where we are in the budget process and everything else that's going on to try to not create a whole, not grow government, so to speak, but to make this more accountable and more transparent. So in that respect, I can't say that, no, we were trying to establish a whole brand-new entity outside of the Department of Corrections. What we saw here was kind of not unlike what you all have sometimes with groups and task forces and others, where an agency or legislative researcher, whoever is actually staffing the functions of whatever that is. And right now, that already appears to us, not knowing any more about the internal workings of KDOC than we do, that it already exists and is operating in one fashion or another. And compensation was something else that we talked about, and I know Supervisor Thompson brought that up. I mean, I recall way back then, I want to say it was, like district judge pay or some variation of that theme. But understanding that those folks were full-time people. I mean, they were all over the state. Former Attorney General Stovall, for example, was on the parole board years ago when we were all in a different life. So, and I think DOC chairman does have, she handed me a copy of her testimony, and there's some real clarity in what Zamuda provided you that you referred to, Representative Carmichael, about this whole post-release versus parole versus whatever, right? And in our heads, layman's heads, and folks dealing with it, parole means, hey, you kind of did your time and you were pretty good character, didn't have a lot of violations, so we're letting you out. And this post-release piece is actually a product, I think, of the sentencing guidelines, and you're going to get that. You're going to get, when you get sentenced, your post-release term is set, and you're going to have that. Right? When you're out, now you're on post-release. Now it has conditions and such, I believe, like parole does. You don't carry a firearm or hang out with other bad guys or whatever. And then when you return, if you get returned because you violate that, then it's for the remainder of that post-release. And then in scenarios like the sheriff was giving us, well, and somebody's charged with a new crime, then they've got to get them convicted, et cetera. So either, if you want to keep them incarcerated, they've got to either be in the county jail without bond, so to speak, or keep getting revoked and returned by the Department of Corrections. It's not a super good system, but you can see the numbers, that 5,400 number that the last conferee was talking about, total number of decisions. That's of that, there was like 4,000 release plans that they approved, 1,100 parole revocations, 307 parole eligibility decisions. So deciding if somebody was even going to be considered for parole, there's like 307 of those. So you can kind of get a sense of how those things break down from that, I think. Hope that was helpful.
It was, do you contemplate that if we pass the bill as written, that what I'll call the staff, the people who help the parole board, the 5 in this case, that they would be KDOC employees, and so KDOC would be obligated to provide that staff to them, or would they have a separate staff? How does, if you...
I don't want to wiggle too much on this, Chairman. You could, you all as the policymakers can set that up either way. It seemed to us, maybe in an oversimplistic way, that this already exists at DOC. They already have staff. They already know the mechanics of all of these things, with the exception of the fact that we need more of an arm's length transaction by the actual parole board members and a different authority appointing them. Can it be housed at the DOC and staff there, and those folks have different business cards or something of one nature or another? Yeah, I think it could probably.
Right, thank you. Representative Carmichael.
Thank you, Mr. Chair. I appreciate this additional opportunity to visit with folks, because I think we're making some conceptual progress here. Right? The devil's in the details. But also and by the way, I don't think KDOC is on our agenda to testify, are they, Mr. Chair?
They put in neutral testimony,
right.
But not
if there was somebody live here, I'd ask them my questions, but I know Mr. Kearney is read.
They are here. I don't know if she wants to speak. Yes, no? Would you? Okay.
Okay, well, it doesn't usually work that way, so let me ask Mr. Kermit the question.
Okay.
You can ask me and I can ask Jeff.
Yeah, right. Yeah, I'll only answer if I like the question. I don't think that's the way this works. But in KDOC's testimony, as I'm sure you've seen, they talk about the difficulty in recruiting people today when they're just looking for 3 board members, and one of them doesn't have to be from the big first district in western Kansas and, you know, a geographical distribution. And I think what they report is, over the past 2 years, they've advertised for 2 different new members. They received applications from 14 people who met the minimum qualifications, and after interviews, only 6 of those were found to have the relevant experience or met the preferred qualifications for the position. So right now, we're having trouble attracting people for these positions when we're talking about 3 people who are DOC employees who are not geographically distributed, and then they go on to express their concern that with the present salary of the chair being paid between $68,000 and $100,000 a year, and the other 2 board members between $59,000 and $87,000, that they have real concerns, I think, as to whether we're going to get the best and the brightest to take these jobs. I'm not expressing a cure for that, but I'm sure that the Highway Patrol and everybody else wants qualified people in these jobs and not the only hacks we can find.
That's, yeah, if that was sort of a question.
Wouldn't you agree?
I would agree with that, and I do think it goes some to the level of compensation, and then some to the specificity of these various qualifications. I think we do want a higher level of folks, more of a, you know, sort of, and I hesitate to use this term, but sort of more of a quasi-judicial sort of a tribunal of folks that. Right.
Representative Barrett.
Thank you, Mr. Chair, and thanks for providing some of that clarification. So one number you referenced, I believe, is a little over 100 that would actually be for the parole eligibility portion of the 5,000.
Yeah, so I'm just looking here at the testimony, 307 total number of parole eligibility decisions, and what I understand that to be the determination about whether or not you even get considered for parole. So parole eligibility decision, but that's where it rolls in.
Sure, so thank you for that. So that's a way more doable, I would say, than 5,000 compared to having full-time staff versus part-time staff. So would the associations be for and okay with having that separate board that just looks at that, just those parole eligibility cases? Because, like, for example, I sit on a board I don't get compensated for that meets quarterly, and we have no issue getting people in for that because it's not something you have to show up for every week. So are the associations okay with something like that, having that separate board?
You know, Representative, I think our minds aren't closed to anything. What we're looking for is something that functions well, that protects public safety, that is given real consideration to whether or not, you know, some of these really bad folks ought to be out strolling around. So, and, you know, some of them may very well, but we really need that extra consideration, I think. So, yeah, I mean, I'm willing to look at anything, and I'm sure our folks are too. You know, what we're trying to get to are those first components I talked about, and that's all there. Thank you for the question.
Representative James, did you have?
Yes. Thank you, Mr. Chair. Back to what we've been talking about. The last conferee talked about it, and Representative Carmichael talked about it, and Representative Barrett just touched on it, dividing that up.
Right.
There's 5,400, so just help me along because I haven't gone to prison yet.
Right.
And so post-release means they've served their time, but they're out, and they have an additional 12 months to serve as basically good behavior.
I mean,
right?
In the example that was given, a 12-month sentence, 12-month post-release.
Sort of like the military. You serve your 4 years, you get out, you have 4 more years of obligation. Whether you knew it or not, you still have it.
Right.
Okay. So and the only time that you're going to notice this, and the only time you're going to notice they violate is if they've committed some type of a crime or misdemeanor. Is that right?
Yeah, if they're not, and once again, this might be a better DOC question, but if they're not comporting with the conditions of that post-release, whether that's reporting in to, I'm assuming, I don't know if they still call them parole officers or.
Do they report to parole officers? Okay.
So
Okay.
if they're-
So they do have a parole officer.
Right.
Okay. All right. But, you know, we've talked about a lot today, and you said you thought the bill was good, but it doesn't sound like it's that good. It doesn't sound that solid.
Right.
You want $300,000 as a, we don't even know who's gonna work where and how it's gonna be done. And then we have the issue of maybe possibly dividing something that would make the whole process better. So,
It might, Representative, yeah.
yeah. Okay.
But maybe not. I mean, we're only talking about, out of 5,400, 307 eligibility pieces. I don't know.
Seems like a lot of bad guys out there.
There is.
Yeah.
Way too many.
All right. Well, thank you. Thank you, Mr. Chairman.
Yes, sir. Thank you.
Representative Seibert.
Thank you. Just a quick question, kind of follow up on the previous representatives. When they go before the parole board, before they go see the parole board themselves, somebody in the institution has to say that they did okay. Who recommends them to go when they've committed all these crimes in the prison system?
I don't know the answer to that, Representative. I mean, who inside DOC does that? I don't know.
That's what I was going to say. Maybe that's what we need to look at. Who's sending them up to be looked at when they're doing all these crimes? Thank you, Mr. Chair. That's something I'm going to look at.
All right, thank you very much.
Thank you, Chairman. Members?
Let's see, there's a neutral, public defenders, do you wish to speak to the bill? Welcome.
My name's Lindsay Ford. I'm with the BIDS Legislative Committee. I'm a public defender out of Wyandotte County. Most of our concerns that we brought up in our neutral testimony have already been covered by everyone else. It's a big concern we had about transitioning and the timeline there, given based on the neutral testimony provided by KDOC, it looks 94% of what the Prison Review Board is something other than parole. And so having those positions be empty for any period of time would be extremely problematic. Just one minor thing we also want to touch on, and was a small amendment we also proposed. There were the 1,108 review hearings for people accused of violating parole post-release. Currently, those are done by neutral detached bodies, which is the Prisoner Review Board. Under its current composition, there's a lot of case law on the right to counsel there or not because of the current established process. Changing the dynamic of that board to primarily prosecution, law enforcement, and political appointees, we think, without belaboring the point, might trigger some sort of reanalysis of how neutral and detached that would be. I think in order to minimize that, keep broad perspectives, we did, in our written testimony, propose the amendment to also include someone appointed from the Board of Indigent Defense Services, just to keep a breadth of experience and perspectives on a board like that. But then, I think the big thing that everybody has already noticed, identified, and discussed at length here today is the timeline and just the importance of the Prisoner Review Board independent of the parole considerations. So if there are any questions left, I would be happy to stand for those.
Thank you. Any questions for the conferee? Seeing none, appreciate it. Thank you. All right, committee, so I think we had a good discussion. We'll probably be thinking about this for a while and working on maybe some amendments, so look forward to that. Also, Teresa, have we gotten all our minutes passed out yet? Okay, so in our next meeting, which I believe is Wednesday or Thursday, be ready to approve or make changes to the minutes. And otherwise, I think we're done for the day. Thank you. Adjourned.